That'll let me know that you're ready to go.
Judge, good morning. Albert Garcia, if you're ready for a quick announcement.
Go ahead, I'm ready.
Judge, I'm on cause number CL 202770H, and we have a status conference this morning. Jennifer Regalado is the opposing counsel. I don't know if she's on.
Good morning, Your Honor. I'm here.
There she is. Judge, our announcement is we're set for trial February 14th. We mediated the case on Friday. We were able to settle with one plaintiff, Ms. De Leon, Rosa De Leon. We were not, unfortunately, able to settle with the other plaintiff, Mayra Espinosa. So we're ready for trial, or at least plaintiff is ready for trial on February 14th with respect to Ms. Espinosa's claim.
All right, what says Ms. Regalado?
Your Honor, I'm going to ask for a continuance. I don't know if you'd rather wait till the pretrial, because the reason mainly is that I have a very old case, like a 2014 case set in one of the other courts. So I don't know if you'd rather wait till it's closer to figure out how likely it is that that case will go, or if you want me to ask for it now.
What court is it out of?
Let me check real quick, Your Honor. It's a case I recently got, so I'm not that familiar with it.
So
It's in the 90. It's in the 92nd, Your Honor.
Okay.
Judge, if the court will hear me, I'm not opposed to that. I actually have another trial around that time in Travis County, so I wouldn't be opposed to a continuance anyway.
Okay, so you're okay with me putting you back on the docket board at this time, Mr. Garcia?
Yes, yes, Your Honor.
Okay. So let me give you a new DCC. February 2nd, 2021 at 2:30. And you will be removed from the docket board for trial on the 14th.
Thank you, Your Honor.
Okay,
Thank you, Judge. I have nothing further. May I be excused?
you're excused. Thank you.
May I be excused as well, Your Honor?
Oh, 2022. I'm sorry. I said 2021. I apologize. 2022. Yes, thank you.
Thank you.
Everybody take care. Be safe.
All right, thank you. Mr. Haley, Daniel Haley.
Good morning, Your Honor. Daniel Haley on behalf of the defendant, Texas Department of Public Safety. I'm here on cause number CL 210884H. This is a status conference as well as a plea to the jurisdiction and motion for summary judgment, and a motion to exclude as well. I anticipate that the plea to the jurisdiction and the motion for summary judgment that's on the docket for today will take approximately 30 to 45 minutes for counsel to go through. And I can see opposing counsel on the screen, Mr. Moore. I don't know if he agrees with that time announcement.
Good morning, Your Honor. Nick Moore here for Kenya J. Trevino Rodriguez, the plaintiff on this case. As far as the argument timeline that Mr. Haley has provided, I think that's pretty fair. There's a lot of details that go into this argument. However, sort of last minute, Your Honor, the plaintiff has filed a motion to compel mediation as well as a motion for continuance. The motion for continuance, Your Honor, I don't know if you want me to go into it briefly, but part of the basis for that motion for continuance has to do with the evidence that is being alleged in this plea of jurisdiction. This is our first trial setting on February 14th. There's several issues that I think we need to further explore in discovery, but I'm not sure if you want us or want me to go into that now. If you're trying to figure out if you're going to take up this matter right now, or if you want me to reserve that until you believe you have enough time to hear all the issues.
Right. Yes, if we don't mind, if y'all don't mind waiting, obviously this is not a quick announcement, Mr. Haley. So if you can just hang tight, obviously this is going to take about 30 minutes. I'm sure, I'm more than positive there's going to be some quicker announcements, and just hang tight. We'll be right with you. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Mr. Garza, are you have an announcement on one of your cases?
Judge, yes, Your Honor. Good morning, Judge. I have a petition for occupational driver's license, Your Honor.
Okay.
I'm not sure if that qualifies, Your
Yeah,
Honor.
of course. CL 214146H in Re Samantha Marie Arredondo.
She's present, Your Honor.
All right. Ms. Kimberly, is it Kimberly Arredondo?
Yes.
All right. Ms. Arredondo, can I have you raise your right hand? Do you swear to tell the truth? Oh, I'm sorry. No. I apologize, Ms. Kimberly. I have two Arredondos, and I now see that there's a Samantha Arredondo who I think is the petitioner on this case. So I apologize, Kimberly. We'll put you on mute for just a second because I think I need to ask Ms. Samantha Arredondo to raise her right hand.
Okay, no problem.
Thank you. Ms. Samantha Arredondo, can I have you raise your right hand?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your true and correct name, Samantha Maria Arredondo?
Yes.
All right. Mr. Garza, do you have any questions for your client?
Just basic ones, Your Honor.
ahead.
Samantha, you were, thank you, Judge. Samantha, your license was suspended due to a alleged DWI that occurred November 7th, 2021. Is that correct?
Yes, sir.
And as a result of that, you do have a intoxilizer machine on your vehicle. Is that correct?
Yes, they did crash me though, so I'm not driving at the moment. And
All right. So basically, you had an accident with that vehicle, and you're not operating the vehicle at this time.
yes.
All right, but it's still installed in that vehicle.
Yes.
And is it true that you're not driving any other vehicle? Is that correct?
Yes.
Okay, and you asked this court for a license you need a temporary occupational license. Is that correct?
Yes.
Do you work, ma'am?
Yes.
And you're asking the court in petition to allow you to travel in particular counties that are better described in that document. Is that correct?
Yes.
And you provided an SR 22 as well to the court and attached it to your pleading? Is that
Yes.
correct?
Mhm.
You're asking the court to approve this license. Is that correct?
Yes.
I have no further questions.
Mr. Garcia, do you have any questions?
Just one. Ms. Arredondo, have you ever been, or aside from this one specific incident, have you ever been arrested for a DWI before?
Never.
Your Honor, that's all I have at this time. I did review the petition submitted by the petitioners. They've listed the specific time limits that they would want for the occupational driver's license, which is 7 to 7, if I'm not mistaken. They've listed the specific dates and the specific counties. And being that this is the petitioner's first and only offense, we have no objection to an occupational driver's license, Judge.
Your Honor, I will submit an order to that effect at this point because I wasn't sure what counsel's announcement would be today.
All right, court's going to go ahead and grant the occupational driver's license at this time. Mr. Garza, I know that there has been no order submitted to the court, so if you can submit an order, that would be appreciated, and the court will sign off on it. As soon as I get it, Ms. Arredondo, from Mr. Garza, we'll sign off on it, okay?
I will do that today, Your Honor,
Thank you, Mr. Garza.
in accordance with what Your Honor ordered today as well.
Perfect, thank you.
Thank you, Judge. May I be excused, Your Honor?
You and your client are excused.
Thank you, Judge.
Judge, having nothing more before this honorable court, may I be excused?
You're excused, thank you.
Thank you, Judge.
Mr. Rodriguez, Ricardo Rodriguez, what do you have? Mr. Rodriguez, you're on mute.
I'm sorry, Your Honor. It is CL-17-0298-H.
All right.
Fifth,
Yeah,
Third
Fifth
Bank.
Bank versus Pedro Salinas and Juan Salinas.
That is correct, Your Honor. We are here on a motion to retain. We're asking for 60 days. I'm representing the Fifth and Third Bank as a local counsel. And I don't know if the defendant is present.
They appeared here in court, Judge. They just walked in.
Okay, they're the ones that are present here in court. So they are present here. Mr. Rodriguez, they are present in court, Pedro Salinas and Juan Salinas.
Okay, you know, and the reason why we're asking for a continuance here, motion to retain for 60 days, is because there was a notice that the court sent and we received on December the 10th of 2021, setting it for this hearing today. But after that notice, we received the answer filed by the defendants. So that changed the whole situation or strategy on where, you know, instead of going for the full judgment, now we need to consider either summary judgment and also the opportunity to talk to the defendant, see if we can reach an agreement to do some negotiations. That way we're asking this honorable court to grant us a 60 days continuance.
Okay, Pedro Salinas, Carlos, can you translate or let them know if you can you hear me first of all, Carlos? Okay, Pedro Salinas and Juan Salinas are present in the courtroom. Mr. Rodriguez, can you please let the Salinas family know? I'm assuming they're family, but maybe they're not. Can you let them know that plaintiff's counsel, Mr. Rodriguez, is asking for a continuance for 60 days? Do they have any objection to that 60-day continuance?
This account was sent to the bankruptcy department without us being notified.
You filed for bankruptcy?
No,
Who filed for bankruptcy?
the bank itself.
Ladies and gentlemen,
This account was being paid. The truck was stolen. So we continue paying because the insurance denied the services. So we continue paying. We have receipts here for the pay. And all of a sudden, they sent a letter that the account was sent to bankruptcy department.
Hold on. Mr. Rodriguez, can you hear that? I don't think you can. So what I'm going to do is I'm going to put myself on mute so that she can speak on the camera that's here in the courtroom, so that, because I don't want there to be any interference. So I'm going to put myself on mute. They're here in the courtroom. That way she can speak about some bankruptcy issues and make you aware of it. Okay, Mr. Rodriguez? Because otherwise I think we're just going to be going around in circles on this case, and this case has been pending for 1,800 days. So I'm going to place myself on mute and let her speak.
Okay.
Can you hear?
Okay, my name is Petra Salinas. I'm his wife, and I'm the one handling the account. This truck was stolen in February of 2015. The insurance denied the services, so we continued paying it. I have proof here where we've been paying. And then a year later, we received a letter from the bank stating that this account had been transferred to the bankrupt department without being notified to ourselves. So it also says that they were not going to continue for charging for the account, but it will show on our credit report, which it is. It is showing as a repo when it was never repo. It was stolen. We continued paying a year later, even though we didn't have the truck. And then we received this letter from the bank where they took it upon themselves to change it into the bankrupt department without us being notified. So now we've been having the creditor collectors calling us that we still owe this money. So who do we believe? We continued paying. The bank decided not to continue our loan, and they closed the account going into the bankrupt department without us being notified.
Okay, Mr. Rodriguez, you've heard kind of an argument that they've brought up. Do you have anything to add? I know that you're only local counsel in this matter.
Yes, you know, and that's part of the reason why we need more time to prepare for this case, because before they had filed an answer, we were just assuming that it was going to be a default judgment. But now that they are appearing and that they're raising all these, you know, issues, well, those issues need to be addressed, and we need to, prepare for make a decision what we need to do. My client needs to make a decision what they need to do, where they wanna see if they can negotiate and reach an agreement with the defendants or something else.
Do you all have, or have you all ever communicated with Fifth Third Bank in any way?
They don't give me information because the account is closed. And I have sent copies of this information to the creditors that they have been sending us letters. So I have been sending all this information to them, letting them know why the account was not paid. The bank decided to close the account without us being notified, even though we have proof that we were paying. So we did our part.
Okay. Let me go ahead and give the parties 60 days notice or time so that they can determine. Obviously, Mr. Rodriguez, I think a summary judgment would fall upon deaf ears here. So you probably want to avoid, that's not going to go anywhere. So let's not waste time with the summary judgment. I think they've already raised a sufficient claim here. So you're probably going to want to look at other avenues in how to resolve this case. And reaching out to them would probably be the first step. I'll give you a 60-day reset, Mr. Rodriguez. All right, March the 30th, 2022 at 9:30 in the morning, okay? Yes.
Okay, thank you, Your Honor.
Thank you.
And I have another case, Your Honor, in this court.
All right, go ahead.
That is CL-19-6638-H. It's Unifund.
All right, the Unifund CCR LLC versus Juan D. Salazar. Is Juan D. Salazar present?
This is Juan Salazar. Yeah.
All right, Mr. Salazar is present on the phone, Mr. Rodriguez.
Yes, well, we were, this hearing was set for default judgment.
No, it was set for a status conference hearing. Oral hearing was requested by plaintiff's counsel.
Okay, I'm sorry about that. I confused it with another one. Okay, so again, on this one, Your Honor, we would like to a 30 days continuance to explore the possibility of reaching an agreement with the defendant.
You want 30 days or 60 days?
60 days, I'm sorry.
All right. Mr. Salazar, you've heard Mr. Rodriguez asking for a 60-day continuance. Do you have any objection?
No, I do not, Judge.
Okay, let me go ahead and give you March the 30th, same day as the other case at 9:30, Mr. Rodriguez. March 30th at 9:30.
Thank you, Your Honor. And those are the only cases that I have this morning on this honorable court. May I be excused?
You and Mr. Salazar are both excused. We'll see you both on the 30th of March at 9:30.
Thank you very much.
All right, Heather Abreu.
Thank you, Your Honor. I'm here on matter CL 203891H, Juan Pachuca versus Santos Hernandez Garcia and Mario R. Guerra.
Good morning, Judge. Oscar Alani is also involved in that case. I represent the defendants.
Good morning to both of you. I have a note here that said the case settled. Is that correct?
No, Judge.
No.
Don't.
Number 9.
Not our matter. No, Your Honor, we are still conducting depositions in this matter, and we have a mediation that we're scheduled. We were just asking for a continuance in this matter so that we can continue trying to get this one settled.
I'm in agreement with that, Judge. Also furthering her requests.
Okay, so you all were sitting at number, I guess you all have moved up to number 2 for the week, and you all are announcing not ready and asking for some additional time and needing a new DCC. Am I hearing that correct?
Yes,
Yes,
Judge.
Your Honor.
Okay, perfect. Let me give you a new DCC. February 2nd, 2022 at 3 p.m.
Okay, thank you.
You're welcome.
Thank you, Judge.
Thank you.
May we be excused, Your Honor?
Yes, both of y'all are excused. Thank you.
Thank you.
All right. Now, Mr. Jaime Hernandez, what do you have?
Good morning, Your Honor. Jaime Hernandez here on behalf of Kimberly Arredondo on cause number, oops, give me 1 second, Judge. It is a family law case. It's an F cause.
Is it F0051-228 in the interest of Emiliano Vargas, a child?
Yes, Your Honor, that would be it.
All right, I do have Ms. Arredondo now who's logged on. Who's on the other side of this?
Your Honor, the person's name, the defendant's name is Jonathan Maximiliano Vargas. I don't see that he is signed on, Your Honor.
Jonathan Vargas, if you're logged on and on mute, please unmute yourself. Jonathan Vargas. Was he served, Mr. Hernandez?
He was, Your Honor.
So properly served. When was he served? How much notice was he given or lead time?
1 second, Your Honor. Let me pull that really quick. I'm looking at SPA here really quick. Was served on 1/10/2022.
Okay, so 2 weeks ago. So he's had plenty of time.
Yes, Your Honor.
Okay, our staff is telling us that we did give him notice. We did call in, we did speak, we gave him notice of today's hearing.
Yep, and we
What is
sent
it you requested?
letters as well, actually. So we served him and we sent him also a letter of the order setting hearing as well.
Okay, and what are you requesting?
Your Honor, we are requesting that my client be named, well, we were asking for sole managing conservatorship, supervised visits against the father due to family violence, and minimum wage on child support, Your Honor.
You want to go ahead and ask your client some questions and proffer that evidence. Ms. Arredondo, can I have you raise your right hand and unmute yourself, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Hernandez, go ahead.
Good morning, Ms. Arredondo. Can you please state your name for the record?
Kimberly Arredondo?
And Ms. Arredondo, you currently have a child, and the child's name is Emiliano Vargas, is that correct?
That's correct.
And his date of birth is July the 2nd of 2015?
Yes.
And the father of this child is Jonathan Maximiliano Vargas, is that correct?
Yes.
And we did file a petition, and in that petition, you are requesting to be sole managing conservatorship, is that correct?
That's correct.
And the reason you are asking for sole managing conservatorship is because of the existing physical and mental abuse that you have endured as to or from Mr. Vargas, is that correct?
That's correct.
And due to that family violence, you're also requesting that any visitation between Jonathan Vargas and the child be supervised, is that correct?
Yes, that's correct.
And as far as the supervised visits, you're asking the court to grant you, or to grant him actually, visits every other Saturday from 12 to 4, is that correct?
Yes, that's correct.
And you're asking that those visits be in a public place?
Yes.
And you're asking that those visits be supervised by you or another competent adult?
Yes.
And I know we haven't discussed an actual location But can you tell the court a public location such as Chuck E. Cheese, Peter Piper Pizza that you would be okay with, and the address of that location?
Yeah, the Chuck E. Cheese by the Expressway on McAllen and Palms Crossings.
And you would be okay with doing supervised visits, like I said, every other Saturday? So we would do, let's do first and third Saturday of each month,
Yes,
and for 4 hours from 12 to 4.
yes,
As far as child support is concerned, you're asking the court to grant you a temporary order ordering child support to be in minimum wage. Is that correct?
that's correct.
Your Honor, I have no further questions of Ms. Arredondo.
All right, Mr. Hernandez. There being no further questions, the court's going to go ahead and approve the temporary orders that were read into the record by counsel. So that relief is granted at this time. Mr. Hernandez, if you can submit an order.
Absolutely, Your Honor. I will get that prepared today and sent over.
Ms. Arredondo, good luck to you. I guess at this point, I'll just wait, Mr. Hernandez. I don't need to give you another date. You'll notify the court, you'll submit an order setting hearing.
Yes, Your Honor, we'll go ahead and do that.
Perfect. Thank you so much.
Thank you, Your Honor. May we both be excused?
Both of you are excused. Thank you.
You have a wonderful.
Thank you.
Thank you. I have a name change that I think I can take care of relatively quickly. F5582-218, in Ray Iris Darlene Solis. Iris Solis is logged on. Ms. Solis, if you can hear me.
Yes, Your Honor.
All right, good morning.
Good morning.
Can I please have you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Is your true and correct name Iris Darlene Solis?
That's correct.
And you're seeking to change your name, is that correct?
That is correct.
Can you provide the court with a brief explanation as to, first and foremost, why you are seeking to change your name? And then we'll get into the name change and the specifics.
Okay. I would like to change my last name to Morin. Morin is the current last name for my grandmother and the family that actually raised me. Solis is actually my biological father's last name, which in my 31 years, I have never met this person, don't know anything about him, nor do I know how he looks like. So I would like to change the last name to who actually raised me.
All right. And I understand that a criminal history was filed and that it came out with no criminal history. Is that your understanding as well?
That's correct.
And you're requesting the name change at this time from the court. And was an order ever submitted to the court?
I believe so. Let me see.
1 second. We just want to make sure that we do have an order. 1 second.
Maybe not.
I'll request it from the clerk's office.
But they do have it?
There is a proposed order on file.
Okay, there is an order on file, Ms. Solis, soon to be Ms. Morin, and as soon as I sign off on that order, the court will go ahead and grant your name change, okay?
Thank you, Your Honor.
All right, and you've had a chance to look at that order that you submitted, is that correct?
That's correct.
And it's true and correct, and if I sign off on it, it's with your consent and with your approval, is that correct?
That is correct.
Perfect, the court will go ahead and sign off on that, and we'll change your name to Iris Darlene Morin.
Thank you. Thank you, Your Honor.
You're welcome. Thank you so much. You're excused.
All right, thank you very much.
All right, Mr. Davis, and now I don't see Ms. Diaz.
Yes, sir. Good morning, Judge.
Good morning.
Looks like Melinda stepped away for a second.
Okay, I do see Mr. Garcia and Ms. Garcia. I know that the other case they told me was going to take about 30 to 40 minutes. I don't know if y'all wanted to wait that long. I wanted to try to take care of this one relatively quickly. I know I have Mr. Gonzalez who notified me that he is stepped away as well. So Gonzalez, you're back?
Yes, Your Honor. Thank you. Sorry about that.
Nope, no worries. We're trying to get a hold of, is Hector Bustos still on this case? To your
He is, Your
knowledge?
Honor. He
Hello.
is.
All right, this case is currently setting at number 1 for the week. Are you announcing ready for trial?
We are, Your Honor. We have a summary judgment that is pending before the court, and a second summary judgment that is set to be heard on Wednesday. And I don't believe we received a response to that second summary judgment.
Okay, well then, what we'll do is we'll wait until Wednesday. We'll push today's hearing till Wednesday. We'll see where we're at. Mr. Bustos is not logged on. And like I said, you are currently sitting at number 1 for the week. So it is
Okay.
the one going to trial.
What I'll do, Your Honor, if you don't mind, I'll just go back on to silent on mine, and I'll email his office just to see if he was planning on joining, because I don't know if there may be an issue, because I was surprised that there wasn't a response to the summary judgment.
Okay, sure, no problem. I know that we're probably going to be here for about a good hour. So
Okay.
okay,
Right. Thank you, Your Honor.
You're welcome. All right, Melinda and Mr. Davis, this is
Yes, good morning, Your Honor.
F06-2021 8.
Yes, sir. Judge Tim Davis for Mr. David Garcia.
Melinda Diaz for Amanda Garcia, Judge.
All right, what do we have this morning?
Judge, back on January 12th, we were set and the court took some evidence, and what was before the court, part of what was before the court was our motion to modify on the child support obligation. The judge, you granted that beginning January 1st of this year, and then you set us to come back today for Mr. Garcia to tell you whether or not he had gotten a job with.
That's right. Yeah, I remember.
Yeah.
He was to get a job, and the question was whether or not he was going to be able to get that job, whether he was underemploying himself, according to Ms. Diaz, and whether or not he was. There's a lot of questions that were still left.
But
Yeah.
Judge, but Judge, the questions that were answered, Judge, apparently Mr. Tim Davis and I are not in agreement with what was actually answered. If I may just recap for the court real quick, we went over the amount of child support. And although at the time I had told the judge that his child support obligation was $1,290.96, that $290.96 had been deferred for a future date. And that was part of my motion, Judge, that I had asked that. I had also informed the court that they were going to be selling their house. They were supposed to close on the 19th. Unfortunately, Judge, because of COVID, they're not going to close until tomorrow, from my understanding, on the 25th. But having said that, Judge, it was part of my motion that all the child support that was due and owing, the court had ordered for it to be paid. Mr.
That's a separate
If I may
motion,
finish,
Judge.
if
Well,
I
wasn't
understand, Judge.
finished.
But we haven't been able to turn in an order because Mr. Davis doesn't agree with what our order is and what the judge ruled. And he said, well, we're going to be there on the 24th. We can ask the court at that time.
Well, that's
So
that's right. That's Ms. Diaz's motion that was also heard on the 12th. But first, I think for the first motion was our modification. And I can tell you, I talked to Mr. Garcia this morning. He did not get the job at LNF. And that's what the court had initially told us to come back on today to get that information.
Okay.
Judge, even though we haven't been able to resolve the first issue, we needed the court's ruling because Mr. Davis disagrees with what my understanding and my client's understanding was of the ruling.
Okay, but from what I remember, the ruling of the court was that I was going to allow whatever was due and owing up to that point to be withdrawn from the proceeds of the sale of the home.
Right.
That was my
agree.
understanding, Judge.
Now, the issue is, Judge, on that, and we're off by, or the disagreement is about $2,900. And on page 15 of the temporary orders, that's where the court ordered child support of $1,290.96 a month to begin March 15th, but that Mr. Garcia would pay $1,000 per month beginning on March 15th until the house was sold. So he made those, and we agree that He made those $1,000 per month payments through July of this year. Then after he had lost his job, he wasn't able to pay as much, but we've agreed on the amount that he paid. What the disagreement is now, and we also agree that he's ultimately going to owe her those $290.96 per month for those 10 months. Now, Ms. Diaz's motion is saying that her client, there's arrears, and her clients should get the arrears paid out of a portion of what my client's going to get from the sale of the house. We agree with that, except I do not agree, and there's nothing in the record to indicate that the $290.96 are in arrears, because they're not in arrears, because that amount didn't go into effect until the house sold, and the house won't sell until tomorrow. So it cannot be arrears. So we're agreeing that she should get $8,026 from Mr. Garcia's portion of the closing proceeds. And that is the medical arrears, $352 a month times 10 months. And then the child support arrears calculated as per the temporary orders in this case.
First of all, Judge, I didn't call it arrears. When Mr. Tim Davis brought that to my attention, I took that off the order, but my motion specifically addressed the additional $290 that was going to be due and owing at a future date. My motion addressed it, my argument to the court addressed it, and Your Honor addressed it. You said the full amount of everything he was going to pay, because that is not considered arrears, Judge. That's just something the judge said he'll pay it at a future date. It's not getting erased, he'll pay it at a future date. And we were taking into consideration when he would sell the house. Well, despite the fact that maybe the house doesn't close until tomorrow, at the time that we went before the court, the house was supposed to close that Friday. We had no foreseeable reason to think that it wasn't. But nonetheless, it's supposed to be closed tomorrow, Judge, and that $290.96 should be added. We requested the court for it to be added, and my understanding is the court had already granted it. The full amount of anything that he owed as of March 15th.
So 290 with 96 cents, is that the total amount that's in dispute, or is that?
Times 10.
Times 10.
Times 10.
All right.
And quite frankly, go ahead, Judge.
And that's 2,909.60. Now, where does that amount come from, out of curiosity?
Because
because
the
the
original
court had
child
ordered
support
him-
amount was $1,296 or whatever it was, $1,290.96 per month.
That's the original amount of child support and medical.
But what the court ordered was that he would pay $1,000 per month beginning March 15th, and that the remaining obligation of $290.96 shall be deferred and will continue to accumulate at a future date. And that the child support was not going to kick up to the $1,290.96 until the house had sold, because the testimony back then in February was that Mr. Garcia was in the house. He was continuing to make the mortgage payment on the house. So that's why Your Honor ordered that. So all we're saying is, we're not saying he's not going to owe that. He is. That's what the temporary orders are. We're just saying it shouldn't be taken out right now from his portion of the sales proceeds of the house, because he's not behind on that.
And you're saying that it should be listed as like a payment plan 2 and reduce that amount of $100 a month, or what is it?
Well, perhaps when we finalize the case, or perhaps we'll, work it out some other way. But as far as for them going in tomorrow and being able to close this, and they're each going to get 50% of the sales proceeds, that, Ms. Garcia is entitled to, under my calculations, it was $8,026. And that's the arrears that My client should have paid with the $1,000 a month in child support through December and the $352 per month in medical and dental support.
Judge, this was addressed at the previous hearing. We specifically addressed the $296 or $290.96. And at the time, the court ruled all amount of child support was going to be due and owing once the house was sold. And then and from there, this hearing, the court would consider what's his child support going to be now. She has gone to over 10 months, Judge, because now we're already on past the 15th of January. So the January 15th payment didn't get paid either. She's gone with having to be supporting these children because there's times that he sends her $296, $300. He wasn't even sending the 1,000. He didn't pay anything on the medical insurance that's being taken out of her paycheck, Judge. So it's always been to her detriment and to her hardship. And so, Judge, we're asking the court to continue with its ruling that the full amount of everything that was already ordered be paid.
Okay. It just makes sense that the full amount be paid at this time so that it could be removed from the proceeds, because otherwise, who knows if she'll ever get it. So the court will order that it be withdrawn from the proceeds of the sale. So $2,909.60 is going to be removed from the proceeds as well.
And just for the record, Melinda, what was that? You have the dollar amount figure, correct?
The total amount was $10,935.60. $3,520 came from medical that he had not paid, $7,415.60 from the child support. And just for clarifications, that's only till December. That did not include January.
Right. We agree.
So if we were to include January, it would be an addition.
Right, but we're not including January because that's why we're here today, to determine what his obligation is going to be as of January 1st.
Going forward, correct. So now Mr. Davis has another argument that he's not employed and he should have his child support reduced down to minimum wage, I suspect. Is that correct, Mr. Davis? Or is that not before the
Judge? We have nothing else to base it on. He doesn't have, he didn't get the job.
Right, but you're making that request.
Yes, sir.
Okay, and the court's going to grant that because he doesn't have the job.
But Judge,
I understand your argument, Ms. Diaz. I understand that you're going to argue that he's underemploying himself. At this point, he doesn't have employment. If he does get employment in the future, you can bring it to the court.
Well, Judge, what incentive does he have to get employment when it's going to raise his child support? Right now, the court's encouraging him stay unemployed.
I am being mindful of the fact that he is unemployed. That's what I'm being mindful of.
And I understand, Judge, and is the court also considering that he'll have at least
I was
another?
mindful of the fact that your client should receive her $2,900 today.
I understand that,
I'm
Judge.
being mindful all the way around.
So you're ordering it at $7.25, Judge, even though he testified that every job he's looked at is at least $12 an hour. And with his training and education, the court is still going to order it at $7.25 an hour?
He doesn't have a job right now. I didn't hear anything else.
Well, right, Judge. And he also said he couldn't verify all the places he's been looking. We had no evidence that he's actually looked for a job, Judge. And in fact, the court heard that he didn't even.
Did you have anybody from LNF that can testify to the fact that he didn't tell him, hey, you know what, withdraw my application. I don't want the job. I mean, I'll hear that if you want.
Judge, he's saying it's not our burden to prove that he can't get employment. It's his burden to show that he's made the effort. Once we argue that he's not being diligent in his efforts, the burden falls on him to show that, in fact, he has been diligent. And what did he tell the court? He doesn't know the places. He has no copies of any of his applications. He doesn't keep track of them. How is that showing the court that he's been diligent in looking for a job when he himself can't even show a court one application that he's filed? Because he supposedly does it on the portal and can't get a copy of it.
Ms. Diaz, didn't you call somebody, a representative from LNF, and speak to them last time we were on the phone?
I did call one person, yes, Judge.
Okay. I mean, what more do you expect me to do?
No, I don't expect the court to do.
You did that.
I did that, Judge, but I would expect the court to take into consideration that he's been unemployed for almost a year, and we only have one place that he looked for a job, one place that he just now applied for less than a month ago. And yet he's been unemployed for almost a year, and we're supposed to take that as due diligence in looking for a job because he had one place in 1 year. And that's enough for the court. That's enough to show due diligence of efforts to find a job.
That was not the evidence, that it was just one place.
Well, that's the only thing he could prove, Judge, and the only thing that he gave me that I could call someone. Everything else, I don't know, I don't remember, I don't have the applications, I can't download anything. That was his excuse, Judge. So all he gave me one name and I called it. But that's all he gave me, Judge, and he even testified he had just applied for that a few weeks before. But he's been unemployed for longer than that.
Right, and I think that at that point, if I remember correctly, he was scheduled to go in that Friday, and the court held back to make sure that he would get that job. So if you want to bring that representative from LNF, I can hold off on hearing this until Wednesday and bring him in and see what the reason for LNF deciding not to hire him was.
Yes, Judge, I would love that.
No, has you already made a ruling on this? Because how many?
No, I haven't made a ruling on it. I'm going to rule on it on Wednesday when Ms. Diaz either brings or does not bring that witness. I mean, if she wants to go and, it's very possible that LNF is going to say, we had a better applicant. We had a better qualified person and we hired someone else. We didn't hire him. Okay. I mean, Ms. Diaz's argument is there's so many jobs out there and that he's so qualified. Okay. Well, I mean, this is a job that he may not have qualified for. Okay. Next, oh, well, everyone's paying $15. No, they're not. They're paying $7.25.
No, Judge, what he testified to is all the jobs he claims he applied for were at least $12 an hour, Judge. And I think the court's been around town seeing everywhere, hiring people. But,
yes, Belinda, but those are minimum wage jobs that people
no, they're not, Your Honor. No, they're not, Judge.
I mean, okay. Well, I'm not going to get into that argument with you right now. The court's going to make a ruling, and the ruling is I'm going to postpone today's hearing on the modification of Mr. Davis's modification to Wednesday. And I guess we'll know before Wednesday how the closing tomorrow went. And then we'll go from there. We'll see you on Wednesday.
Yes, Judge.
All right.
Yes,
At
Judge.
9:30?
9:30.
Thank you, Judge.
All right. Mr. Bustos.
Good morning, Judge. Sorry about that, Judge. Thank you for waiting for me, Judge.
No problem. You are sitting at number 1 for trial on the week of February the 14th. Docket call on the 10th. Mr. Gonzalez is present as well. He was mentioning something about a summary judgment that is set for Wednesday, if I'm not mistaken.
That is correct, Judge. Yes, and the case is we haven't mediated this case as well, Judge.
Okay. Well, okay. So you all still have some work to do. Are we basically going to see each other, I guess, on Wednesday at 9:30 for the summary judgment?
Yes, sir.
Okay.
We are, Your Honor. The only thing is, I don't think I've seen a response to this summary judgment. And it might be helpful if we just confirm that issue. If there is one, I'd like a copy of it. I mean, I still want to have a hearing on Wednesday, but it'd be nice to have that. And on the mediation issue, both Mr. Bustos and I had some interesting scheduling issues since mid-December. Would ask the court to extend our mediation deadline until the final pretrial of February 10 so that we can schedule a date before the 10th.
That'll be ordered. That'll be granted. You have until the 10th.
Thank you, Judge.
Okay. We'll see you on Wednesday then.
All right, Judge. Thank you.
Perfect. Thank you, guys. Remember, y'all are sitting number 1.
Thank you.
Okay, Judge.
All right. Thanks. Okay, that brings us back to Mr. Haley and Mr. Moore. Now okay, hold on, Ms. Kennedy. Kennedy.
And Your Honor, she's actually my division chief with the Attorney General's office. She is also here representing the Texas Department of Public Safety.
Okay, perfect.
As well as I am.
Let me just make sure I have everybody else. Jonathan Vargas. I just want to make sure. Mr. Vargas, can you hear me?
Yes, sir.
All right, Mr. Vargas, you logged on late. I had already called your case. I'm going to ask that you reach out to Mr. Jaime Hernandez. Let me at this time see if I can locate his number for you. Give me 1 second. You can have something to write with. I'm going to give you his number, okay?
956.
Area code 956
212
212
9302.
9302. Did you get that?
956.
Okay, one more time, Eddie, can you give it to me?
Yes, 212
212
93
93
02.
02.
Y es el abogado de
Ese es el abogado de la señora Hernández, el abogado de la mamá del niño.
y tengo que hablar a ella.
Sí, habla con él porque ya el caso ya se cerró por hora. ¿Ok?
Y una pregunta, ¿qué es lo que tengo que hablar con él?
Pues para que le explique lo que se decidió hoy, porque no se puso en la corte a las 9:30 como estaba asignado.
Es que batallé para, no se quería hacer daño, batallé bastante y agarré tu teléfono.
Ok. Él le va a explicar lo que la corte decidió, ¿ok?
Muy bien.
All right.
Una
Let's move
pregunta
over.
más. Perdón, no tengo abogado, no sé qué puedo hacer.
Por eso le digo que él está representando a la mamá de su hijo. So, hable con él y él explica, porque usted se está representando solo.
Bueno, para conseguir, ¿me podrían dar tiempo para conseguir un abogado?
Sí, ¿cómo no?
Muy bien.
Ok.
¿Y cuándo volvería a presentar en corte?
No tenemos esa cita porque el abogado tiene que pedirnos tiempo o cuándo quiere venir a regresar. So, a este momento no le puedo decir cuándo va a regresar porque no le he dado fecha.
Muy bien.
Este caso nomás tiene 14 días o 2 semanas. So, estamos al principio de este proceso.
Tengo entendido que quería que me hiciera un examen de cabello, algo así.
Él no me dijo nada de eso ahora.
Muy bien, gracias.
Ok, hable con él.
Gracias.
De nada. All right, let's go back. CL 210884H, Kenya Treviño Rodriguez versus Texas Department of Public Safety.
Yes, Your Honor. We're here today on a status conference, a plea to the jurisdiction, motion for summary judgment, as well as a motion to exclude. However, very late last night, I believe 7:30, 7:45 sometime, plaintiff's counsel filed a motion to compel mediation. It's going to be my argument that mediation is not going to be very productive considering there's still a pending jurisdictional matter that's before the court. But then also while you were taking up other matters with other counsel before hearing our case, plaintiff's counsel did go ahead and file a motion for continuance. So not only do I think that notice is untimely, I am going to object to that motion to continuance.
Let me ask you this question. Why after 331 days are you barely filing a plea to the jurisdiction? Isn't that one of the first things? I mean, didn't we learn that in first year law school?
Well, no, Your Honor, because a plea to the jurisdiction has to at least allow for adequate time for discovery. But yes, once it is before the court, then that is when the trial court, the Texas Supreme Court has said the trial court has to determine then at its earliest opportunity whether it has the constitutional or statutory authority to even hear a case. But the plea to the jurisdiction, we still have to, once we file our answer, we still have to flesh out the jurisdictional issues and allow time for discovery to actually elapse. And so that's what we did in this case is we filed our answer, once we did some written discovery, including the disclosures. Then after the disclosures happened, we did requests for production, interrogatories, admissions, and then a series of depositions. And then all of a sudden we're in the fall, and that's when the plea to the jurisdiction, or late fall, early winter is when we finally filed it, just before the dispositive motion deadline happened. But you are correct that the court is required to take it up at its earliest opportunity.
Your Honor, their motion or their plea to jurisdiction was filed on December 7th, so I wouldn't call that a filing in fall. And because of the short notice on this, several issues have been raised in the plea to jurisdiction, issues that I believe are tantamount to being explored for trial. But I'll let you guide what arguments you want to hear first. But that is a topic of issue for me.
Well, I mean, look, you guys are sitting at 1 of 5 now. Everything else is washed out. We got to you guys. And that's typically what happens in our court, right? People ask for continuances. People say they're ready, not ready. If you've heard this morning, everybody has announced not ready. And so you go from sitting at number 5 of 5 to sitting at number 1. I mean, I guess my question is, everyone knew going into this that there was a docket call. Everybody knew going into this that there was going to be trial on the 14th. And yet we waited to this point to file the plea to the jurisdiction and then to try to get dispositive issues heard. Okay, I don't mind hearing them. And then are you guys going to be ready for trial on the 14th of February is the question. If I don't rule in the state's favor. That's ultimately my question.
Well, Your Honor, I think if that's the case, then there probably is some mediation and other issues that would have to be taken up. So I don't think either side would be ready at that point on the 14th. But I don't think that December 7th, this is the earliest opportunity that we've had for a hearing date. Filing something on December 7th is not late filed, in my opinion. We're going to allow 21 days for the motion for summary judgment to be filed and for them to have an answer. But then, obviously the holidays happen. And then with the court schedule, this was originally going to be scheduled on January 12th, I believe. But then because of the court schedule, it got pushed back and the court staff just pushed it to the date of the status conference. So of course I would have preferred to have this done much earlier, and it could have been, but just because of scheduling and also the amount of discovery that had to happen before we got to this point, before I could file a plea to the jurisdiction.
Mr. Moore, you're asking for a continuance then because you're not prepared to respond to the plea to the jurisdiction?
No, Your Honor. Well, fortunately, yes, to be honest with you. We are asking for continuance partly because, as opposing counsel stated, mediation hasn't been conducted. That's a local rule of Hidalgo County that we have mediation before trial. Obviously,
right, but hold on. But before we get to there, I mean, we got to take up the plea to the jurisdiction before you guys can even go to mediation. So when would you be ready to hear the plea to the jurisdiction?
Yes, Your Honor. So that was the second point I was going to get. Opposing counsel mentioned that he waited till discovery was adequate or complete in order to file a plea to jurisdiction. With his plea to jurisdiction, as well as his reply to my response, certain information has come to light, such as the issue regarding, part of it is a letter of representation that was presented to opposing counsel and the other party. And in their latest filing on Friday, just last Friday, I'm finding out that they're claiming this letter of representation isn't valid, that it wasn't properly provided. There was discovery exchange, and one of the requests is correspondence. We never produced a letter of representation under the false assumption that they already had it, considering the fact that we set that at the onset of the case. It's only coming to light now that they're providing this notice issue, that they weren't provided proper notice according to the Texas Rules of Civil Procedure. I need to find further evidence to validate this letter of representation because they're stating that there's no evidence to support the fact that it was actually mailed or it was actually received. And I only found out about this last Friday, Your Honor. So part of it is going into discovery regarding that particular issue, whether or not we did provide proper notice. Additionally, Your Honor, we deposed their trooper for an hour and a half, and several immunity issues have been raised in the plea to jurisdiction. I'd like to reopen the deposition with that trooper, Raul Matias. And in their plea, they also have an affidavit by his supervisor, his direct supervisor, Sergeant, and I'd like to depose him regarding what he's testified to in his affidavit. Lastly, Your Honor, one of the accusations we make is that this is potentially a flawed investigation. This is a Texas DPS trooper collision with a private citizen, and then the accident itself was actually investigated by the Texas DPS. It's our position that that's a biased investigation. However, that's circumstantial evidence, and at this time, we would like more time to discover whether or not there's any evidence within their intake, within any documents they have withheld to show that possibly this is a fraudulent or I guess flawed investigation. And that's imperative to know now because it's a factor in whether or not we evaluate if immunity applies here. And so the statute of limitations on this cause of action is this August, Your Honor. And so if we're able to find evidence of fraud in this particular case, and that may come short, Your Honor. I will admit that that's possibly a long shot, but that is a leg we are curious about looking into. If all that falls short, we would consider non-suiting this matter if we don't have a legal leg to stand on. But as it stands right now, Your Honor, I believe there's enough evidence involved that there's still a question as to a lot of these issues that the plea to jurisdiction argues about today, Your Honor.
Brief response, Your Honor. In his motion for the continuance, which was just filed, minutes before we started taking this up, the only basis for the motion for continuance is to further explore this fraud issue that he's talking about. So not only do I think fraud did not occur, which there's no facts, and he even admitted just now that it sounds like it's purely circumstantial. So speculation cannot be a basis for a continuance, but also let's say he does amend to allege fraud. Fraud is an intentional tort that is not covered under the Texas Tort Claims Act. If he amends for the fraud issue under CPRC 101.057, I will immediately file a motion for summary judgment and a plea to jurisdiction again. And the court will have no choice but to grant it because it's an intentional tort that's not covered under the TTCA, and there's no waiver of sovereign immunity. So that's not even a basis that he can further explore. I mean, he can explore it, but it's futile. There's no reason for it. And if the other basis for exploring, further discovery after, like the court said, this has been pending for almost a year now. I mean, we filed an answer on March 23rd in this case. If the only basis that he has to go on is purely circumstantial, I'm using his words, purely circumstantial, that is speculation on his part, and that is not a basis for continuance. I'm ready to go on this plea to the jurisdiction on this motion for summary judgment. I've prepped all of last week. I prepped over the weekend. He had since December 7th to look into these issues. And these issues have been at the forefront of the case. I mean, I made a big deal about it in all of my discovery. I asserted sovereign immunity in my answer on March 23rd. All the written discovery has sovereign immunity issues just at the forefront. The depositions had sovereign immunity and notice issues at the forefront. He had adequate notice of this. There's nothing new other than some affidavits that were filed on December 7th. And then this new letter that he attached to his response, which is unauthenticated, and which I can get into if we get to the PTJ issue today. But I just don't think there's really any basis whatsoever for a continuance at this point. I'm ready to go on the PTJ. It sounds like the court's ready to go. I think we should have that hearing today.
Yeah, if you want to have that hearing, I understand. But once again, opposing counsel misrepresents. Earlier, he said they filed it in fall when it was December. Here he's saying that the only reason for the motion continuance was to explore fraud. That's patently false. We did file this just before the hearing, Your Honor. A large part of our staff has Omicron, so there's issues. I expected it to be filed earlier. It was filed last minute. In there, I list mediation has not been conducted, which I understand, as you addressed earlier, we need to have the plea to jurisdiction in order to have mediation to make sure it's fruitful. Additionally, Your Honor, I list all the things I just stated with regard to reopening the deposition of Trooper Macias, with having a deposition of the sergeant, with whether or not the sufficiency of the notice of claim we provided opposing counsel is credible. And lastly, whether or not there's any evidence to stand on the cause of action for fraud. There's multiple reasons in this motion. I don't know why opposing counsel is shaking his head. I filed it, Your Honor. You can see paragraph number 3 where it lists all those things. I'm not sure if he's got a redacted version of that or what's going on here, but there's multiple reasons there for the motion to continue.
And Your Honor, I'm shaking my head because he's talking about fraud again. That's not an allegation that he can move forward with under the Texas Tort Claims Act. And then he talks about other things like reopening depositions for purely speculative reasons. And for those reasons, those are not a basis for a continuance. I think we should go ahead with the plea to the jurisdiction this morning.
And additionally, Your Honor, it would be brought under the Texas Tort Claims Act. It'd be brought as a claim for fraud. But anyway, Your Honor.
And you wouldn't be able to, because there is no waiver of sovereign immunity for fraud against a governmental entity.
Okay, Mr. Moore, clearly, or are you at the office right now? I mean,
no, I had to work from home today, Your Honor. I have some plumbers coming by for some home issues.
Okay. Mr. Haley, you're prepared to go forward?
Yes, Your Honor.
And it's been set since the 9th of December?
The motion was filed on December 7th.
All right, go forward.
Thank you, Your Honor. Let me just get everything, my screen ready. Again, Your Honor, like I said before, this is a plea to the jurisdiction and motion for summary judgment hearing where I want to focus on three primary issues, any of which, if the court believes and grants, would be automatically dismissal of this case. There is a motion to exclude that is part of my plea to the jurisdiction, which I know sometimes courts like to take up motions to exclude evidence at the very beginning, but I think because of some of the legal issues and the timeline, it might make sense to go through my first argument and then discuss the motion to exclude, if that's okay with Your Honor.
Sure, go ahead.
Okay, thank you. So first of all, there's three issues I want to discuss today. First is that the plaintiff failed to provide adequate notice to the defendant as required by Civil Practice and Remedies Code, section 101.101. Second, the defendant is entitled to sovereign immunity because of the emergency exception that applies in this case. And then finally, the defendant is entitled to official immunity. And just a brief recitation of the facts for Your Honor, this case centers around an auto accident that occurred on August 15th of 2020. The defendant driver was a state trooper in Hidalgo County who was on routine patrol. The trooper, his name is Trooper Raul Macias. He was dispatched to an emergency call for service for a hit and run collision that had just occurred. Shortly after being dispatched to the call, he turned onto Dillon Road in Weslaco, along with a white SUV that was traveling in front of him. He attempted to pass the white SUV in an area where it is legal to pass. And while attempting to pass her, the white SUV, who is the plaintiff in this case, she turned left and collided into the right side of the trooper. It pushed him off into a ditch, into an embankment area on the side of the road. And then following this collision, the incident, which was investigated by another trooper from a neighboring DPS station, he reviewed the scene of the collision. He talked to both parties involved and determined that the plaintiff was the sole contributing factor to the collision for turning when unsafe. And that brings us to the first issue, which is addressed in the plea to the jurisdiction, which is notice. And again, this kind of involves a little bit of a timeline for how the case proceeded. The first issue, again, is notice under CPRC 101.101A. Plaintiff is required to send written notice to the defendant that lays out three descriptors. The plaintiff must give notice that must reasonably describe the injury, must reasonably describe the time and place of the incident, as well as the incident itself. And DPS's position in this case is that the first time it learned of any claim that the plaintiff was making in this case was when it received the citation, the plaintiff's original petition on March 8th of 2021. So this is, of course, more than 6 months past the date of the incident when this incident arose. So the deadline itself would have passed on February 15th of 2021. And so, we're more than 6 months at that point. And to support its contention that the defendant never received notice, defendant sent a request for admission to the plaintiff in which she did admit without objection that she failed to provide DPS notice in accordance with CPRC 101.101. And then additionally, in request for production number 19, plaintiff was required to produce all documents reflecting communications with the defendant. Plaintiff, without objection again, turned over a lot of documents, but none of which showed any communication occurred prior to February 15th of 2021, which is the statutory notice deadline in this case. So therefore, the defendant has already conclusively established as a matter of law that it never received any written notice in this case. Alternatively, what the plaintiff could have done, which is a more difficult task, is attempting to establish that the governmental entity had actual knowledge that the claimant had received some injury or that the claimant's property had been damaged. This actual knowledge requirement has been explained in case law to mean that the governmental entity's subjective awareness of its fault in causing the injury or property damage. Again, the Texas Supreme Court has said that subjective awareness of its responsibility for causing the injuries claimed, and that's in the University of Texas Southwest Medical Center at Dallas versus Arancibia, which, for the courts, just so that the court is aware, that's 324 Southwest 3rd 544. That's a 2010 Texas Supreme Court case. And so just to be clear, this means more than the governmental entity's awareness that a collision happened, but it's subjective awareness of its fault for causing the collision. And in this case, plaintiff fails to meet that
It
burden.
doesn't say for its fault, it has that they received injury anyway.
Okay. I'll give you your opportunity to provide any rebuttal argument, Mr. Moore, but in this case, the plaintiff fails to meet that burden as there's zero evidence that's been presented to this court that prior to receiving the citation and original petition, which was more than 6 months after this accident, that DPS ever had any subjective knowledge or awareness of its fault in causing this collision. Indeed, to this day, DPS still denies liability in this case. And I believe that plaintiff's counsels failed to conduct any discovery on this matter whatsoever. When you look at the crash report, it shows that the plaintiff was at fault. The trooper's supervisor, and this is all exhibits to my plea to the jurisdiction, Your Honor. The crash report itself shows that the plaintiff was at fault. The trooper supervisor concluded that the plaintiff was at fault. The DPS state crash coordinator who reviewed this collision, as he reviews all collisions involving DPS officers, he determined that the plaintiff was at fault. At no point can the plaintiff establish or produce even a scintilla of evidence to show that DPS had any subjective awareness of its fault in this case. And so therefore, because there's no written notice and because there's no actual notice, because no subjective awareness of fault, DPS is entitled to dismissal of this suit on its plea to the jurisdiction and motion for summary judgment because plaintiff has failed to establish any jurisdiction. And so in this case, after I filed my plea to the jurisdiction, which was back in December, on last Monday in the evening on January 17th, for the first time ever, plaintiff produces a letter of representation that they allege was sent to the DPS station in Weslaco. I object to this letter being offered as evidence on several grounds. First, it's unauthenticated. They are offering it to show that they did put DPS on notice. However, there's no evidence in the letter itself or attached to the letter to show that it was ever sent to DPS. It's just a letter with no fax confirmation, no certified mail with return receipt requested. There's nothing to show that it was ever actually sent to DPS. I conferred with DPS, their general counsel's office, who conferred with the DPS station in Weslaco, and their records coordinator in Weslaco has provided an affidavit, which I attached as Exhibit B to my reply to plaintiff's response, in which they say that they have no record whatsoever of ever receiving this letter of representation. Additionally, remember, we had requested copies of all communications between the parties kind of close to the outset of this case, and it was in my request for production number 19, which is attached as Exhibit A to my reply. And without objection, they provided a lot of documents. One of the documents, if you look at Exhibit A in my reply, you'll see that everything they produced is basically medical records, and there is a letter of representation in it, but it's dated June 18th of 2021. So they have this early letter of rep that they are alleging shows notice, but there's actually no evidence to show that we ever received it. And then there's also another letter of representation, which wasn't timely noticed anyway, so it's kind of moot. But also the whole letter issue is moot to begin with because they're using that to allege written notice when they've already admitted in a request for admission to not complying with the notice requirements under CPRC 101.101. That letter is moot. There's no objection. It can't be withdrawn now. And then the letter itself doesn't even comply with the notice requirements. When you look at it, it gives a date and then says that a plaintiff was involved in an accident with a trooper. It doesn't give the location as required in CPRC 101.101. And it doesn't give a description of the incident as required in 101.101. So for those reasons, just all of that alone on my first issue, the notice, they have failed to meet their burden to show that any notice was given to DPS. And therefore, without any rebuttal as to those issues on these legal arguments, the plea to the jurisdiction and motion for summary judgment should be granted on that ground alone. But then there's two other issues that I still haven't got to. There's also an emergency exception, which applies to the facts of this case. As stated in our written plea, the trooper was responding to a hit and run collision that had just occurred. And in the course of that response, he was struck by the plaintiff as he was passing her vehicle. There are exceptions to the waiver of sovereign immunity under the Texas Tort Claims Act. And in section 101.021 of the Civil Practice and Remedies Code, it lays out the emergency exception. And essentially, this exception is for torts that arise during an emergency response situation. It applies from the action of an employee while responding to an emergency call or reacting to an emergency situation if the action is in compliance with the laws and ordinances applicable to emergency action, or in the absence of such a law or ordinance, if the action is not taken with conscious indifference or reckless disregard for the safety of others. The evidence clearly establishes that Trooper Macias was responding to an emergency call. It was a call for a hit and run collision that had just occurred minutes prior, and none of the evidence itself shows that he acted recklessly or conscious disregard for the safety of others. Plaintiff's counsel is going to try to point to the fact that before he turned onto a street, he kind of took a wide turn. I failed to see how that, if he's behind the plaintiff, I failed to see how that shows a conscious disregard for the safety of others. The response type itself was a discretionary act, and the evidence shows that the roadway at the time was clear and dry. The Texas Supreme Court has held that once the defendant makes a showing of an emergency exception, there's a burden shift toward the plaintiff now. Plaintiff's claims are barred unless the plaintiff meets her burden and shows competent evidence that Trooper Macias was not responding to an emergency call or reacting to an emergency situation, and or that he acted recklessly or conscious disregard. The evidence clearly establishes in this case that Trooper Macias was en route to an emergency call for service for a hit and run collision that had just happened. The plaintiff does not refute this evidence at all that he was responding to an emergency call, but merely states that because he didn't have his lights on, that he acted recklessly and with conscious disregard. However, that's a mere factor to consider when determining whether an emergency response is taking place. And it's actually not the standard here. They needed to refute that he was actually conducting an emergency response. So just for the court's notice, there's a Houston Court of Appeals case that was actually authored by Justice Guzman, who was later on the Texas Supreme Court, but it's the DPS versus Little case in which the Court of Appeals held that a trooper who did not have his emergency lights on was still able to use the emergency exception, and went on to state that the use of emergency lights itself is not a determining factor in whether he's making an emergency response, because using emergency lights is discretionary. And so because of the case law in this case and CPRC 101.021, the Texas Supreme Court requires the plaintiff to present some evidence to prove that the trooper was not responding to an emergency situation. And the plaintiff in this case has not done so at all. Therefore, the court should grant the plea to the jurisdiction and motion for summary judgment on that ground as well. There's no evidence to refute that he wasn't responding to an emergency. And we all know that responding to a hit and run call that had just occurred, that is an emergency. And then finally, the law of official immunity applies here as well. The plaintiff, she focused her response on the idea that the defendant misstated the law and that the law of official immunity is not applicable here, but they failed to rebut any of the elements that are laid out in the plea to the jurisdiction and motion for summary judgment. And so therefore, if official immunity does apply here, which I believe it does, they failed to contest any of those elements in their written response. And so the plea to the jurisdiction and motion for summary judgment should be granted because they failed to rebut any of those arguments. But just to go into the law of official immunity, DPS does have sovereign immunity in cases where official immunity applies under Civil Practice Remedies Code 101.0211B. So if a governmental employee is not liable because of his or her official immunity, then the governmental unit cannot be liable either. That's according to a Texas Supreme Court case, Harris County versus Sykes, as well as the City of Dallas versus Brooks, which is a 2011 Dallas Appellate Court case. In DeWitt versus Harris County, a 1995 Texas Supreme Court case, the court held that if an employee is protected from liability by official immunity, the governmental entity retains its governmental immunity. Nothing requires that the employee actually be named in the lawsuit like the plaintiff asserts in her response. Thus, official immunity would apply in the case if the defendant can meet the elements, which it can. So plaintiff is going to try and argue that because the trooper himself is not individually named, that official immunity doesn't apply, but that's just a misstatement of the law because in Civil Practice and Remedies Code 101.106E, it requires dismissal of individual government employees if they're named in their individual capacity. So, you can't really balance the two together. I really just don't understand plaintiff's response that official immunity doesn't apply, but official immunity applies where a public official performs a discretionary function while acting. We already talked about discretionary functions in the course and scope of their employment, and that they were acting in good faith. A discretionary function, as outlined in that first element, requires personal deliberation, decision, and judgment, such as a state trooper deciding when and how he would respond to a hit and run collision. And then I cite to the City of Lancaster versus Chambers case, where the Texas Supreme Court has held that a police officer responding to an emergency call or even conducting a traffic stop is a discretionary function in the performance of their job. The second element is whether the officer was in the course and scope of his employment. I don't think there's any question here, even that the plaintiff challenges that he was in the course of the scope of his employment. Trooper Macias, he was responding to a hit and run call on behalf of DPS. And then finally, whether he acted in good faith. This depends on how a reasonably prudent officer could have assessed both the need to which an officer responds and the risks of the officer's course of action. So even if the trooper made or committed some violation of law, good faith can still apply. The Texas Supreme Court held in the Wadowitz case that findings of negligence or violations of law do not bar an individual from invoking the protection of official immunity. So once the reasonably prudent officer standard is established, which I did establish in the affidavits that were attached to my plea to the jurisdiction. So once that standard has been established, the moving party's proof of good faith can only be controverted by expert evidence that no reasonable officer in the position of the officer in question could have believed that the facts were such that they justified his conduct. And that's directly from the Chambers case. That's the Texas Supreme Court case that I had just cited to. And so in this case, DPS has established all the elements of official immunity through the affidavits of expert witnesses who have been properly noticed as expert witnesses. That's Trooper Macias, as well as his supervisor, Sergeant Olivares. And these affidavits are uncontroverted at this time by the plaintiff. So therefore, plaintiff does not meet her burden in this case under that standard either. So not only did plaintiff fail to counter any of the testimony from Trooper Macias and Sergeant Olivares with expert testimony, she failed to address the issue whatsoever, other than to say incorrectly that official immunity doesn't even apply. So thus the failure to address it whatsoever in their written response means, and that the plea to the jurisdiction and the motion for summary judgment should be granted on those grounds as well. So Your Honor, overall, just to sum up everything, the plaintiff failed to meet its burden throughout this case. There's no notice that was ever sent to the defendant prior to filing suit. The defendant could not have known in a timely manner that a claim was being brought against it as required in CPRC 101.101. The emergency exception applies in this case to the manner in which the trooper was responding to the emergency call for service. And there's no evidence to suggest that he was not responding to an emergency call, so you could grant it under those grounds as well. And then finally, DPS is protected by the doctrine of official immunity for the reasons that I had previously just laid out, and I won't go through all that again, but just that the defendant respectfully asks that the court grant this plea to the jurisdiction and its motion for summary judgment on each of these grounds. I'm happy to answer any questions that Your Honor may have, and thank you.
All right, thank you, Mr. Haley. Mr. Moore.
Your Honor, I'm sorry to interrupt, but I'm not sure whether Mr. Haley addressed the motion to exclude or the objections on the evidence. Did you want to do that now?
Yeah, I kind of went through it a little bit, is that they provided this new letter as it was attached to their response. It was Exhibit D. I filed an objection to it. I did talk about how it's unauthenticated. It doesn't show in any way that it was ever provided. And also they've already admitted to the notice issue under 101.101A. So it's moot at this point. And so I would just renew that objection. And I don't know if you need to hear that before Mr. Moore goes into his argument and rule on it, but that is my objection to Exhibit D.
Okay, thank you. I'll hear from Mr. Moore.
Yes, Your Honor. So just to address the issues and arguments presented by opposing counsel. First is the notice requirement that he's arguing about. It requires that notice be provided 6 months ahead of filing suit. In this particular case, suit was filed on February 24th of 2021. Your Honor, the letter of representation I provided was sent by mail on August 27, 2020. Obviously, defense counsel is disputing its credibility or whether or not it was ever actually sent. In that letter of representation, it says the name of our client, the date of the accident, but also he refers to the University of Texas law. The opinion there on actual notice is the government's subjective knowledge that the claimant has received some injury, one, or that the claimant's property has been damaged. Opposing counsel has filed the police report. In that police report, it shows that the property damage was a rating out of 10. My client's vehicle was essentially undrivable after the collision. I mean, that's actual knowledge unless they somehow, I mean, it's in the police report. It's acknowledged actual damage. And additionally, it says that their EMS staff personnel assessed my client. So it goes to both injury and to property damage. So there was actual damage, whether or not you want to talk about the written notice or if you want to talk about the actual incident that gave them knowledge. Now, he is throwing in the word cause. The case law doesn't say cause, it says subjective knowledge that the claimant has received some injury or that the claimant's property has been damaged. Additionally, Your Honor, I understand that they're saying that they never received this letter of representation, but we have notes back in August 2020 where we're talking back and forth with Westlaco and we're getting information from Westlaco DTS. So there was early communications with that department regarding this claim. So this allegation that they knew nothing about this early on, it's just not true, Your Honor. Furthermore, we talk about overcoming sovereign immunity. In this particular case, to get over sovereign immunity, Your Honor, he must be essentially, let me pull it up, Your Honor, excuse me. So he was asking questions about why I brought up the Texas Transportation Code when I deposed the trooper. In order to apply sovereign immunity, the trooper's actions must be in compliance with the laws and ordinances applicable, and they were taken with no conscious indifference or reckless disregard for the safety of others. All right, so that's two different things, Your Honor. That's one, by the regulations and ordinances in place, and then secondly, was it reckless with the disregard for others? An exhibit has been provided, Your Honor, of the dash cam video, so the court is able to review the actual incident if they need to review, any of the reasonableness standards that go into the law here. If the court needs to take this under advisement. But in this particular case, Your Honor, the client the defendant trooper takes a wide turn onto basically a rural street, 2 lanes. My client applies the brake and she's taking a left into a residential street. While this is happening, and you'll have an opportunity to review the video yourself, Your Honor, to test the validity of what I'm saying right now. The trooper pulls out into the left lane and speeds up to get past my client when my client turns into the residential area and he hits her on the driver's side door. Now, I brought up the wide turn to show that he wasn't following the ordinance because at the time he's not using his emergency light. Why is that relevant? Well, when using the emergency light, it advises other drivers on the road that this individual, this trooper, is actually pursuing an emergency. So that is relevant. Whether or not it's dispositive of the entire emergency exclusion, I'm not making that position, Your Honor. I'm just saying it's a factor. Additionally, we also brought up Texas Transportation Code regarding passing a vehicle on the left, and the trooper was able or testified to the fact that his path did interfere with her ability to turn. When asked, he never testified to any concern about her well-being or about he never applied the brake. Nothing was taken to avoid this collision, Your Honor. And I believe when you review the footage, you're seeing that he's coming from almost a stop position on this turn, and he sees the blinker blink twice, and somehow he's not able to stop and avoid this individual. If this was any other individual, Your Honor, if this was 2 cars and we didn't have a police officer, but it was just some other private citizen trying to pass her, that other driver would be at fault. But for whatever reason, this trooper said about 14 times in his deposition that it was a legal maneuver, but I don't know what a legal maneuver is without citing any kind of, statutory law, case law, but he didn't cite anything, Your Honor. He just said it was a legal maneuver, and that's something that defense counsel keeps saying as well. I believe it was a reckless disregard, Your Honor, because he didn't have to go that route in order to pursue this hit and run. He could have gone on the right, could have waited for a turn, hit options. So that's the factor of discretion. defense counsel talks about discretion when he goes into official immunity. But first, Your Honor, I believe starting with the notice, we had proper notice. I believe that his driving was in a manner that was reckless, just by the very fact that what he testified to, he wasn't concerned about her well-being. He didn't apply the brake. And if you're watching the video, it's very clear he's speeding up into the collision, Your Honor. As far as official immunity, it is defense counsel's argument that the official immunity prevents that Trooper Macias has any personal liability on this, and it's a three-pronged test. He went through it, and I'm not trying to put you to sleep, Your Honor. But the first part was a discretionary function. Basically, the function itself, did he have other options? That's the question. Was what he did, reasonable under the circumstances? In this particular case, case law weighs in whether or not another officer would have behaved the same way under the same circumstances. In this particular case, he's going after a hit and run. He's going to investigate another car accident. And the risk he took is causing another car accident to pursue that. Now, there's different situations where if an officer is investigating a murder, you weigh the risk versus the harm in this particular case. In this particular case, he's creating another accident, go search and investigate another accident. I don't believe any officer or normal citizen would find that reasonable, Your Honor. Defense counsel is correct in that we're not challenging it. He was in the course and scope of his employment. It is in the accident report. He testified to the fact that he's reporting to a hit and run. But lastly, Your Honor, we would argue that he wasn't acting in good faith in how he operated the vehicle. And I don't believe the DPS was acting in good faith when they found that he was not at fault for this accident. He was going against traffic, speeding up to overtake an individual on a rural road that was turning into a residential address. If this individual was a private citizen, we wouldn't be here. And I know that's, of course, that's why we talk about immunity, but that's exactly what it says under sovereign immunity. If that person would be found liable if they were a private citizen, then those actions are to be considered as to liability for Texas CPS, not obviously Trooper Macias individually. He's defended through the sovereign immunity and the normal immunity, Your Honor, official immunity, excuse me. We are taking the position right now at this time that the official immunity is flawed. I don't think that defense counsel meets three prongs when it comes to his discretionary function or whether or not he was acting in good faith, Your Honor. I believe there's sufficient evidence here for a jury to evaluate and find who's at fault, to look at this case. And I don't believe that the trooper here should be protected by his sovereign immunity. I think it's important. I agree that sovereign immunity is important for police officers, especially because they have to take risks, they have to risk their lives in order to investigate, crimes such as murders, assault, domestic abuse, things like that. We need immunity to protect these individuals, government agencies and entities. So that way people pursue that. We have people that work those jobs. However, in this particular case, Your Honor, he wasn't exhibiting, reasonable care for the other driver. There's only one other car. This is 10 o'clock at night. There's no other car on the street. This individual just braking and taking a left. It's just a young girl, and he's trying to overtake her going against traffic with no emergency lights. And, we're supposed to look at that and say, well, he should have known that he was coming on the opposite side. That's reasonable for a trooper to be passing on the opposite side of traffic without emergency lights on. The emergency lights, Your Honor, is a factor to consider because you see emergency lights in your rear mirror, you have to brake, so you pull over. That's, as long as you're not committing a serious crime, at least. And in this particular case, he provided her no notice. I don't believe anything about the way he was driving and operating his vehicle was reasonable or careful. We talk about defensive driving. That's what we teach people when they get a driver's license. But now we're supposed to use a different standard of driving for this trooper, and I don't think that's fair, Your Honor. For that reason, Your Honor, I believe the plea to jurisdiction should be denied. I believe this court does have jurisdiction. I don't believe the trooper's immune and protected by official immunity. Obviously, sovereign immunity would not apply to him, but it would apply to the Texas TPS. I believe we have an exception to the sovereign immunity here, Your Honor. And with that, I'll leave it to you, Your Honor.
All right.
Brief rebuttal, Your Honor, very brief. Opposing counsel is talking about a private citizen standard and saying that if the trooper had been a private citizen, that there would have been a different outcome as to who was assigned fault in this case. That's purely speculative. There's no evidence for that. And then also, I don't know if maybe he's confusing the private citizen standard that's under the waiver of sovereign immunity for premises cases, which is 101.021B, but that's just inapplicable here. This isn't a premises case, so I don't know if maybe that's where he was getting that from. But also he's failed to rebut the official immunity arguments, which is a legal argument, not a factual argument that I made. I did meet all of the elements for official immunity in the evidence and the affidavits that I attached. And so at that point, there is a burden shift for him to rebut with expert evidence testimony. It could have been an affidavit of his own or something, but he never rebutted those arguments. And so official immunity does apply. And because there's no rebuttal with any kind of evidence, including expert witness or expert testimony, on behalf of his client, then he's failed to meet his burden in this case for official immunity. But also the notice issue, he's saying it was sent by mail. Again, he's talking about this letter of representation that's unauthenticated, but he, again, did not rebut the fact that the letter doesn't give the location or the description of the incident. And so therefore, even if Your Honor was going to consider that letter, it still doesn't meet the standards for written notice. But also, again, that issue's moot. He has already admitted in request for admission number 23, which is attached to my original plea to the jurisdiction, that they did not comply with the notice requirements under Civil Practice and Remedies Code 101.101. But also he talked about the actual notice issue. Actual notice under the Texas Tort Claims Act, and I'm quoting from a Texas Supreme Court case right now, requires the governmental unit's knowledge of a death, injury, or property damage, subjective awareness of its fault as ultimately alleged by the claimant in producing or contributing to the claimed death, injury, or property damage, and knowledge of the identity of the parties involved. Fault as it pertains to actual notice is not synonymous with liability. Rather, it implies responsibility for the injury claims. So that's the McQueen case, that's 431 Southwest 3rd, 755, requiring that for actual notice, there needs to be some kind of notice given subjective awareness on the part of the governmental agency of what's being alleged by the claimant. And there's just nothing in the record to indicate that there was any fault, any subjective awareness on the part of DPS as to actual notice in this case. He also cites to a Texas Transportation Code. I think, Your Honor, if you look at that Texas Transportation Code, it is titled passing on the left, but then when you look at it, the statute itself envisions a vehicle that's been passed, not interfering with a vehicle that has been passed, past tense. In this case, there was no passed vehicle yet. They were in the process of passing. That statute is inapplicable here. I won't go into that fully, but then again, he also talks about the emergency lights being a factor. I already pointed out a Houston Court of Appeals case where they said that that's a discretionary act and that there's no requirement that a police officer or other first responder responding to a emergency situation is required to use emergency lights. And again, he hasn't rebutted the fact that he was responding to a hit and run emergency call. And for those reasons, he hasn't rebutted most of the issues that are raised in this case. And I would just ask the court to grant the plea to the jurisdiction and motion for summary judgment.
Ms.
Yeah,
Kennedy, anything to add? Hold on real quick. Ms. Kennedy, anything to add? Okay, Mr. Moore.
Just real brief, he mentions that I'm not rebutting certain factors. It's not essential that I rebut all three prongs in all these arguments, Your Honor. It's important that he's able to prove up all three prongs in all these arguments in his plea to jurisdiction, that, you know, as far as the official immunity goes, that 1, discretionary functions while acting; 2, in the course and scope of their employment; and 3, they were acting in good faith, for example. So with that, it's essential that he's able to prove that all three of those apply to the trooper here. It's not my job to disprove all three. I can disprove 1 or 2 or all 3 And that essentially shows that he doesn't have the immunity applying to him. So that is the reason why I'm not disputing the course and scope of this trooper's employment when it comes to whether or not he was reporting to hit and run. Instead, my argument was that it was not in good faith and not discretionary when you consider the fact that he's reporting to another car crash by causing a car crash. The purpose of that immunity is to look at, if a trooper is facing down, group of gang members or cartel, and they're armed and they're heading across the street. If he caused another accident, well, at least he's trying to pursue somebody that's causing, a death or a serious felony. In this particular case, Your Honor, it was investigation of another car accident. And the case law says that for a reasonable police officer standard, they're supposed to weigh the risk versus harm. I can pull that case law up here in a minute, Your Honor. But
Mr. Moore, let me just, I guess what I keep coming back to is, let me get this straight. We have a trooper who was traveling at night, correct?
Yes, Your Honor.
All right, and was passing a vehicle in a 2-lane highway in the middle of the night without his overhead red and blues.
Correct. Although it's just a rural street, Your Honor. I wouldn't call it a highway. It's not, I think it's like 30 miles per hour on that street.
Oh, okay. But it's not a lit area. It's not a highway. It didn't have any lights.
Correct.
Okay. And so you have a trooper who's passing another vehicle and makes a turn, whether he was coming out of another, was he coming off a side street, or was he behind the vehicle and then overtook the vehicle as the vehicle was hanging a left?
The way the dash cam plays, Your Honor, is both vehicles, it starts right when my client's taking a right at an intersection, and the trooper goes ahead and does the same right following behind her. But as he does his right, it's a wide turn, and he's starting to scoot over against traffic while C is applying her brakes and has her blinker turned to the left. Now, there's a dispute here as to, when that started and when he had a reasonable amount of time to apply his brakes and, essentially, in my argument, be a defensive driver.
So let me ask you. So then they both hang a right, and then she hangs an immediate left?
So he takes a right, and about a few yards down is a left turn to her residence. So she hits the brake and puts on her blinker.
She has every right to do that, right? She has every right to,
right.
She's following the law. She's hanging a left into her residence and has a blinker. And he hangs the right down the street and then overtakes her, but he doesn't have his lights on.
Correct.
Okay. So Mr. Haley, what knowledge or how could we put the blame on her for hanging a left into her residence? Without his overhead lights in the middle of the night, how was she responsible?
Sure, Your Honor, and I understand your question, but I think the facts might be being represented just a little differently. She was not turning into her residence. She was turning into a private driveway to enter a store. That's not really.
That's irrelevant, right? She was lawfully in the right lane, hanging a left with her blinker on.
Sure, but and this is a dispute between the parties, is that he was beginning to overtake her before she put her brake lights.
That's a fact question for a jury to decide, right?
Sure, but that's not the issue that is being brought before the court on this plea of the jurisdiction. These are legal arguments about the manner in which he was responding, which was a discretionary act, even if there's some negligence on the part.
So under what circumstance will an officer say that he didn't have complete discretion to respond? I'm trying to find I'm having a difficult time in why he didn't turn on his overhead lights to at least give notice to the general public that he was coming in the middle of the night. I guess I'm just trying to get over that.
Okay, and Your Honor, my answer to that would just be that that's a fact question. That's not really before the court in any of the 3 plea of the jurisdiction issues that I had discussed. I was talking about official immunity in responding to an emergency situation.
But what emergency if he didn't have his lights on?
Well, there's no requirement that he have his lights on. That is a discretionary act on.
Okay. So, but what emergency then? Because your client said that he was responding to an emergency, or did he need to go to the bathroom and he was, need to get home in a hurry?
Well, I think it's undisputed in this case that he was responding to a hit and run collision.
Okay,
Your Honor, and that's, and just to add, that is part of the factor that was into consideration on the motion for continuance is legitimacy and credibility to that dispatch. And that, obviously right now I don't have evidence to provide to contest the credibility of that claim, but that was part of the reason I wanted to continue it, Your Honor, just to add that fact.
hold on. I'm sorry, say that again, Mr. Moore? You don't have dispatch information that there was a emergency?
I don't have, not to my knowledge, I don't have any written dispatch information. No, Your Honor. The only information I have is his testimony. And I believe there's a brief mention of it in the accident report.
But there's no depot of any dispatch saying, at this hour, at this moment, moments before the accident, we were told of an accident that occurred, hit and run, a mile away, and we gave all troopers notice to respond as quickly as possible. Nothing of that?
Yeah. Unfortunately, no, Your Honor. This is a case that I acquired last June, and I believe depositions, I was trying to pull up the actual dates of the depositions here, but they were pretty late in the year. I'm going to give you a date for a deposition here, Your Honor. September. We had the trooper's deposition in September, but all we have so far is depositions of the trooper and my client, Your Honor.
Okay.
Your Honor, if I can, there is deposition testimony from Trooper Macias that he was responding to a hit and run collision. There is the evidence of the crash report, and I believe there's an audio file of the dispatch itself that has been turned over. I can't pull up my discovery right now without it just blaring a bunch of noise, but that's all been produced. He's aware that there was a hit and run collision. That's undisputed at this time, I think.
Your Honor, I'll look into the audio file he's referencing, but I don't know there was a hit and run that he was reporting to. All I have is the evidence they presented to say that he was. So I don't know anything. There's no way for me to know that unless I saw it all. And so, Your Honor, all of that is up for dispute. And, so I'm not sure why he says I know that. As far as the audio file, that may be there, and I didn't mean to leave that out if it is, so I'll take a look.
And wouldn't the issue be whether the trooper thought he was responding, whether there was or not? The issue is whether the trooper thought he was responding to a hit and run collision, and we already know that from his deposition testimony. So I think that issue is moot as well.
But also, Your Honor, I believe the trooper testified that he was making a legal maneuver several times. So and that goes to the credibility of his testimony, which I believe the prior fact, that's for them to weigh.
All right, guys. Anything else to add?
Nothing further, Your Honor.
All right. Thank you.
Your Honor.
All right. Submit an order. Both of y'all submit orders, please, to the court, and
Yes, sir.
I'll have a decision by Friday.
Thank you,
Thank you, Your Honor.
All right. We'll see each other on the 10th of February. You know what? That's about, hopefully I'll have a decision by Friday, but one way or the other, I guess if this case is over, then we don't, the February 10th is dead. Otherwise, we'll see each other on the February the 10th.
Yes, Your Honor. Thank you.
All right.
Thank you.
Y'all have a good afternoon.
You too. Takes care of our doc.